and when a judgment is written in a manner where all sides think that they have won, I think the credit must go to the court, which has written it so very with dexterity and with a balance. So, with that opening remark, let me straight away go to the issue at hand. The problem which was faced before the judgment came in Safari Retreat, and of course, it came essentially, the lead case is the case coming up from the Odisha High Court, where Justice K.S. Javeri read down the provisions and held that ITC credit was available. But the larger issue which was grappling everybody is this, that is the construction industry sought to be kept out of the ITC, and would this really destroy the fabric of the GST, which is where credit mechanism is the heart of that law? And quite honestly, if, as we pointed out to the Supreme Court, unfortunately there is no reference to it in the judgment, but there were a lot of discussion papers, committees which were set up before the kickoff of GST on 1st of July 2017, which sort of said that GST is a consumption-based tax, destination-based tax, and that it is only on value addition. And that the chain of GST should not be broken because you want to make the transaction cost effective. So anything which increases the cost of the transaction is something that is antithetical to the very concept of GST, was what was discussed and documented in various papers, by various reports of the government also, before GST was really tabled and made it into a law. Now, the argument therefore was that whenever you look to restrict credit and say that I will not allow you to take the benefit of the tax paid on the inputs or input services and yet tax you on the output liability, does it break the chain? Number one. Number two, does it increase the cost of the transaction and really destroys the very basis of value addition tax? And does it really mean that it is not just the end consumer which is suffering the burden of the tax, or it's not just a consumption tax or a destination tax, but a tax even before the stage of final consumption? These were all the points which were canvassed before the court. And while I would believe that the court has not made direct references to those submissions and those reports, it has actually, in a sense, given some meaning and some effect to that argument and submission in the form of introducing the functionality test. But let me not jump the gun and straight away go to the functionality test. Let's first bulletize some of the key takeaways from this judgment. The first is that yes, input tax credit is not a matter of constitutional right or inherent right. It is a right conferred by the statute, and the parliament can always regulate this right. So only to the extent the law provides for, you are entitled to take the credit. Number two, that there is a big difference between Section 17.5C and 17.5D, both of which are exceptions to the general rule of availing credit, whereby credit is not eligible, you are not eligible in these two subclauses of Section 17.5. And the court has said that there is a difference between the two and they are not synonymous. One, it deals with what is the service provided by a works contract service provider. The other is what is received by a person engaged in construction services. The third takeaway key point is that the words plant and machinery appearing in 17.5C, read with the explanation, are different from the words plant or machinery appearing in Section 17.5D. The fourth, of course, is that these services have to be read with what is provided in the schedules, which is section 7 read with the schedules, and the important schedules are schedule 2, where entry 2 and entry 5 have both been analyzed, along with schedule 3, where again the court has analyzed what is the non-taxable area, which is the sale of the land, which is of course not taxable, given the overarching constitutional competence in the form of list 2, entry 49, as it exists in schedule 7 of the constitution. So these are the broad takeaways, and the court in dealing with each of these has come up with the test, which is a test of functionality, to see that ultimately what is the purpose of the construction. And no doubt land and building are excluded from the purview of 17.5c by virtue of the explanation. Yet what would be that qualification which will bring it back within the ambit of land and machinery? So these are the key bullet points. Let me highlight how one could read and analyze the respective clauses 17c and 17.5c and 17.5d in terms of the judgment. The court has, of course, upheld the bar and the ineligibility by saying that one has to strictly refer to the language, the plain meaning, because the court has in the very outset flagged various rules of interpretation of a taxing statute, and one of the salutary principles is to take the literal meaning, which is the golden rule, and don't go by the intent to that extent, and strict meaning should be adopted as far as interpretation of taxing statutes is concerned. Applying that test, the court has said that as far as 15.5c is concerned, the only exception is where there are two exceptions which the court has noticed. One is the exception where the construction of works contract services or works contract services for construction, to put it correctly, are availed for the construction of a plant and machinery. So if you have a works contract given to whoever it may be, the company, it could be an L&T type of a giant or some other such company engaged in works contract. If it is for the plant and machinery, then the input tax credit can be availed. The other is, of course, if the works contract service is in turn used for providing works contract service. And a classic example of this could be that while the main contract will be a works contract, certain subcontracts could also be works contract. And typical examples of this could be something like electrical contract, a plumbing contract, or an air conditioning contract, which also can be a works contract, where there is a lump sum consideration and vivisection is not possible. But that subcontract is part of the larger contract, where the ultimate main contractor is given the responsibility right from the time of designing, engineering, erection, commissioning, and of course the subsequent maintenance if required by the client or the customer. So you could have a works contract which caters to a portion of the larger works contract, and in that scenario also the credit would be available. The challenge really lies because of the definition of plant and machinery. And as we know that in the explanation, which is where this expression is defined, there are certain exceptions. And though the explanation says it is for the purpose of this chapter and chapter 6, the fact that this language of plant and machinery, a conjunctive phrase which has been used, is found only in 17.5c, it now follows, basis the Supreme Court judgment, that the explanation is confined to the, as far as 17.5 is concerned, to clause C and not to clause D. The government tried to argue that there was a mistake of the word or used in 17.5D. As we know now, that there is a difference in the language of 17.5C and 17.5D. 17.5C says plant and machinery. 17.5C D, while carving out the exception, says plant or machinery. And the government tried to present a case that this word or appearing in 17.5D is a mistake, and it should be read as plant and machinery. And we all know that there are 6 of one, half a dozen of the other judgments, which will say that in certain situations, and should be read as or, and or should be read as and. However, in the present case, the Supreme Court has maintained the distinction, and while adopting the literal rule of interpretation, said that no, there is no mistake. In the two clauses C and D, the respective phrases and the words will be read as they stand. So there is a distinction as far as 17.5C and D is concerned, and D will be a case where input tax credit will be allowed if it is used for construction of a plant or machinery. So that difference, I think, today has brought about clarity, although it may be that many people would be hit by the restrictive meaning of the words plant and machinery. Now, so let's go back to the definition of plant and machinery, which is in the explanation. You will see that at the very outset, that this explanation, while defining plant and machinery, has got two negatives. It first defines what a plant and machinery means, and then says what it includes, which is foundation and structural supports. But from the foundation and structural support excludes land, building, or other civil structures. Of course, there are other exclusions like telecom towers and, of course, pipelines which run outside the factory. So therefore, in a scenario like this, if I am constructing a land or a building simpliciter as a civil structure, and it does not constitute plant and machinery, would I be eligible for the purposes of 17.5C? The answer, as Supreme Court has held, is no. If it is simply a land and a building. It has, however, left a window open. And in my view, this is an area of serious debate and discussion. It has left the window open that if I am able to demonstrate, as the person who wants to avail the credit, that the land and building is in fact a plant and machinery which is integrally connected with my business, then I should be able to avail the credit. Now, what could be typical examples of this kind? We have seen that the Supreme Court itself has excluded two types of such structures. It has excluded hotels and it has excluded cinema halls. The rationale behind this seems to be that in Anand Theatres, which is a Supreme Court judgment which has been discussed in this particular judgment, was a case where it was held that cinema is not a plant within the for the purpose of Income Tax Act. And the coordinate bench, because it was a two-judge bench, was constrained probably to hold that since Anand Theatres has taken a particular view, we cannot deviate from that, and hence has said that if it is a hotel or a cinema, then it would not get covered by the expression of plant and machinery, and that would be relegated to the exclusions in the explanation to Section 17.5C. Now, I quite see that there, in fact, if a hotel and a cinema, which is so integrally connected with the business, if that is excluded, what remains? What remains, I will come to little later. But what is the way now to deal with this situation where a hotel, which obviously does provide output services, the hospitality industry is so huge and large that it does provide for output services, and it's a very big contributor to the exchequer in the form of output liability. So hotels do pay GST on the various services that they render, and yet will not get covered now by this judgment because of the exception provided herein. Now, I I'm it's my one can't really say for certainty what went into the reasoning of the court in upholding the exclusion of hotels and cinemas, but I would reckon that it is the decision in Anand Theatres which influenced the court in maintaining or the consistency and adopting and following the ratio in Anand Theatres, which is quite strange because in the same judgment, the Supreme Court has noted that in Karnataka Power Corporation, which was a subsequent judgment of three judges, and in which Anand Theatres has been noticed, the Supreme Court did dilute the ratio of Anand Theatres. And although it has not overruled or it has not set aside Anand Theatres, but it has certainly cast a serious doubt on the validity or correctness of Anand Theatres. Now, if this was a scenario, of course, it was open to the two judges' benches to say that, in view of the fact that the Supreme Court in the subsequent judgment has not followed this ratio of Anand Theatre, and therefore we could not also be bound by it. But the Supreme Court has, in the present case of Safari Retreats, read Karnataka Power as only casting a doubt or casting an aspersion, and has not said that it has conclusively in Karnataka Power held that the buildings which were excluded as not being plant and machinery in Anand Theatres, that ratio will not be followed by us or will not be adopted. So this is one area where the case gets covered by two cracks, and that is unfortunate that the hotels and cinemas get hit only because of the previous cases in Anand Theatres, notwithstanding the fact that Karnataka Power did take a view casting and doubt on the correctness of Anand Theatres. Having said that, therefore, what is the way forward for at least these two industries? The way forward for these two industries, I believe, would be only to make a representation for an amendment in the Act, because only then can you validate a judgment. We all know that the Parliament can remove the defect in a judgment and by a legislative means overcome that judgment, and that such a validation act would be well within the legislative competence of the Parliament. But for now, while the rest of the industries could look at the functionality test and derive some solace from the judgment in Safari Retreats, unfortunately, these two industries will have to stay out for a bit, even though they may satisfy the functionality test. Now, what is this functionality test? So, a simple example, as I said, is of a building or a structure, which is civil structure, which is constructed and is used as a warehouse, and you have a rental income on which you pay GST, and you can take the input tax credit if you are able to show that that is so integral to your business of running a rental warehouse. And we know now with so much of e-commerce that such warehouses are not just for storage, but they also do a lot of other activity. Cement industry, food grain industry, where there is a lot of bulk to retail packing or smaller packaging is done. In such a scenario, would qualify probably for doing some kind of an activity which renders service, and that service of which in the historical days pre-GST era would be called as business auxiliary services or business support services. Today they would be subsumed into the larger piece of Section 7 of the GST Act, and would get covered as a service. Now, if an assessee is able to demonstrate that it is not just a civil structure, but a civil structure which is designed for a particular purpose to achieve a business result of this, then in such a scenario, the credit, in my view, would be available as provided for and held in safari retreats. And that, I think, is the most redeeming feature of this whole judgment, that by introducing the functionality test, it has really paved the way for enlarging the scope of the definitions of plant and machinery, as well as plant or machinery. Although the Supreme Court has upheld the distinction in the language, plant and machinery and plant or machinery, in my view, the word plant, whether read with machinery or disjunctively treated with the word machinery by the use of the word or, in either case, if we are able to demonstrate that the works contract service or the construction is for the plant and the plant is integrally used, even though it may be a civil structure, but integrally used with the business of the person concerned, in that scenario, and the person concerned is subject to output tax, it would really be a classic case of being covered by the exception, and the building would qualify as a plant. Uh, you know, again, the larger principles of such laws, whether it was MODVAT when it was introduced in the late 80s, or the SENVAT which was introduced in the early 2000, or the GST which is now in vogue currently, if you have the ability, when I say you means the government, if the government has the ability to tax the value addition or the cost of what has gone into that service, then certainly the element of tax contained in that cost must also get a set off. So if I have constructed a plant and machinery, plant, which is a civil structure and which is essentially for providing a warehousing facility, the rental that I charge obviously will take into account the cost that I have incurred or suffered in the construction of the warehouse. It may be providing the ventilation, it may be providing with packing machinery, it may be providing with stackers and conveyors or whatever else that is. In that case, the entire cost gets amortized and gets spread over a period of time and is part of my value added service. Now, it is true that many times service providers may not have the luxury of doing it on a cost plus basis because the competitor may be charging something less. And in that scenario, you could probably have a different model. Be that as it may, at the end of the day, the charges that you levy for your output service is a function of what your cost is. And if that cost has also suffered the tax, and you do not get a set off of that tax which is levied on the cost incurred by you, then the very model of simpliciter taxing the value addition or the very model of reducing the cost of a transaction gets defeated. So I think when the Supreme Court has, in I think paragraph 52, 53, introduced the functionality test, this test goes well and beyond the interpretation which the Supreme Court has placed on 17(5)(c) and D. Yes, we respect that difference. We will not obliterate the words and read it as or obliterate the word or and read it as and. And we will respect the distinction between the two subclauses. But if I apply the functionality test to the words plant and machinery, or to the plant by itself, then the net result or the end result should be the same. Of course, as far as 17(5)(d) is concerned, the word or machinery, the machinery examples have been given, solid case has been cited there. Whether the machinery is immovable, the machinery is movable. On the movable machinery, I don't think there was a dispute. And if I remember correctly, the learned ASG had conceded to the fact that if it is a movable machinery on which again GST is levied, there cannot be an issue. So it's only a case of an immovable machinery on which the debate was centered around. Now, in in the case of immovable machinery also, we have a lot of case law, starting with solid machinery or sirpur paper, and more than that, that what constitutes an immovable machinery, and if it is grouted to the earth, and the General Clauses Act definition is also satisfied that it is permanently attached to the earth, and that if on dismantling it will break or will lose its characteristic as a machinery, then those are cases where in machinery construction also the input tax credit would be available. So this, in my view, to a large extent, I can term it fairly and reasonably to be a game changer, that it has introduced this case of functionality. Uh, and I could multiply examples, as I said, of just not of a warehouse, but let's take another case of a port. Let's take another case of a airport. In a case of a seaport, you could have the jetty, which is a civil structure made out of cement, concrete, and metal. And in case of an airport, you could have the whole building, which is designed in a manner that it caters to particular airport services, where there are aero bridges, there is a departure lounge, there is an arrival, there is a check-in counter, there are various other support services which are rendered. And it's not just about having windows and doors, it is about designing it for a particular end use. Now, if those examples are taken, as I said, then in my view, given today the law as laid down in safari retreats, if the person who's the operator of the port or the airport or the operator of the warehouse can demonstrate, and which I think he should be able to do so, that this is the in without this my business is not in existence. If today I am being taxed for providing airport services, then without an airport there is no airport services, without the port there is no port services. So this is a inseparable part of my business, and if the SSE is able to demonstrate, then on the basis of the law laid down in para 52 and 53, in my view, the tax would be certainly be able to set off on what has been paid on the input services and inputs. On the constitutional challenge, I don't think that I, for one, personally speaking, uh, ever had a doubt that it would be struck down as unconstitutional or manifestly arbitrary under Article 14. You would know that after Navjot Sandhu's case, the Supreme Court has said that you can even strike down a parliamentary legislation, a plenary legislation, if it is manifestly arbitrary under Article 14. But I didn't have a doubt on any of those aspects. Even the time limit under 16(4), I don't think that the Supreme Court would have struck that down and said there is a unlimited time for availing credit. Now, therefore, the summary that has been provided for in Supreme Court, where they have said whether a mall or a warehouse or any other building other than a hotel and cinema can be classified as a plant within the meaning, I think that is the key takeaway and the most crucial takeaway. In that sense, if the only exception made out is that if the construction is for sale to a third party, and that would be a classic case of residential premises or office premises, commercial buildings which are constructed only for sale. In that situation, the bar or disqualification under 17(5) and D would continue to apply. And other than that, um, unfortunately, hotel and cinemas have got hit, though I see, and I repeat this and I reiterate, that I see no qualitative difference between an airport, port, and a warehouse, or a mall and a hotel and a cinema. If at the end of the day, each of these persons designs the structure, civil structure, in a manner that it caters to the business and is so very integral to the business that without which the business itself does not exist or cannot be operated, then they would be eligible. But for historical reasons, hotel and cinemas have been kept out. They have a remedy, but it's a very different remedy. Today, the Supreme Court has not. If in one of the somebody asked whether they can file a review, of course, review is you can file, but we know the limitations of a review, that it has got a very narrow scope for judicial review, and therefore may not be the best remedy. But ultimately, if the government wants to maintain parity and avoid any kind of a discrimination, particularly when hotels today contribute a large to the tourism and tourist industry, and the cinemas also in our country, other than cricket, it's the cinemas which are the most sought after. I think that would be something which the government will have to address it at a different level. Uh, I would be open to any questions, and I'll happy to take them if the moderator or the organizers have any such kind of a arrangement done.
Arupji, you are not audible, sir.
Am I audible now? Yeah. So with your permission, I'll just go with the first question. So the first question is already addressed, which is the decision will be applicable to hotel industry or not. I think that is already addressed by you, sir. Next question is that factory building is an integral part of manufacturing. So that also, I think that is also something that you have already shared, that if it's integral to the business, then it can play a dominant role there. So would you want to add on that?
Yes, as the Supreme Court has said, it will much will depend on the facts and circumstances of each case. Now, the difficulty with each of these cases would be that while every factory would be housed in a structure, obviously it can't be open to sky. There will be walls on four sides. There will be a roof. Now, what is it that really is the test to be followed, in the sense that why would such a structure contribute to the activity which is carried out inside the structure, will be a question which the revenue will always try and adopt. And as it was said in the beginning, that the revenue today feels that they have won, because I would think that this is a gray area where there will be a lot of pulls and pressures to say that why is this building so different. Let's assume that it is a textile industry or spinning and weaving. They would say, why is this building so different from a building which normally would house? So just because it has got spinning mills or whatever or the weaving of the warp and weft, or for that matter, assembly line of mobile phones, or any other industry, the burden will be on the assessee to show that how this business has contributed to the very existence of the business, and how this building has been designed to really further the cause of whatever the activity which has been carried out inside. So I think that is going to be one of the challenges, because otherwise they'll say that in every factory, the plant and machinery has to be within four corners of a structure. And hence, by that logic, if every structure gets the benefit of input tax credit, then where is the functionality? So this is one gray area which will give a little bit of a room or handle to the revenue authorities to reject it on the ground that it doesn't satisfy the test of para 42, 52 and 53.
So the next question is about the fate of the matter regarding remanding back to the High Court. So as you know, when we got the news in the WhatsApp that the favorable judgment has come, it was coming as favorable to the taxpayers and all. And later on, during the fine lines, we saw that it's being remanded back to the High Court. So what about the future of this? How does it move? If you could throw some light on this.
So, as we know now, Safari became a test also, which were tagged to the judgment in arising out of the Odisha High Court. That was the case of a mall. And they have remanded it back because they want to see whether these malls, the shops were sold, or was the construction made to sell them outright to third parties and investors, or was it only a lease model business where the owner of the mall who constructed it, he was only interested in getting a lease rental income, and lease being a service under Schedule 2, whether the functionality test is satisfied. So it has remanded it back. But as we know, that more than the matter in relation to malls, there were other matters pending all over the country, and each of those matters pending in various high courts which challenge the constitutional validity were in turn dealing with different businesses and different industries. So all those cases will now get decided by the high courts. It is quite possible, and I don't rule it out completely, that the high courts may also further remand it back to the assessing authority, saying that this requires factual inquiry. And the high courts under Article 226, as you know, are reluctant to get into disputed questions of fact or appreciation of evidence. So it is quite likely that the High Court may send them further down to the assessing officer. And at that stage is where, as I said, the whole discussion about the gray area, which I just flagged in response to the earlier answer question, and that is something that will depend on case-to-case basis.
Okay. So another thing is, one of our participants, in fact, two of our participants were requesting if the concept of plant and machinery was this plant or machinery, if that could be shared once again. Just that part.
Yes. So while the Supreme Court has retained the distinction between the two phrases, plant and machinery and plant or machinery, in effect, what the Supreme Court has done is a common para 52 and 53, which introduced the functionality test, to my mind, apply commonly to both. So even though the Supreme Court has rejected the union's contention that this was a mistake and the word or should be read as the word and, so that the definition in the explanation is applicable, today we have it from the Supreme Court that the definition given in the explanation does not apply to 17(5)(d), which uses the word plant or machinery. So the definition is not applicable to section 17(5)(d). When it comes to determining whether there is a plant or machinery, in addition to what is excluded by the definition, that is land, building, civil structure, telecom towers, and pipelines outside the factory, even to decide whether they are excluded or not to be excluded, the Supreme Court says that if you are able to satisfy, even so, the Supreme Court has said that even if it is excluded by the explanation, the land, building, and civil structure, if you still are able to demonstrate that it is nonetheless a building which is connected directly with the business that I am carrying on, then in that scenario, you could still get back into the definition, and merely being a civil structure by itself will not disqualify you. And this is the area of concern also for us, because we are not sure at this stage how the revenue is going to perceive this. The revenue may say that if it is excluded by statute, building and land, then the moment it is building and land, to read therefore paragraph 52 and 53 widely to say that even though the court was conscious of the fact that the explanation did not cover land and building within the meaning of plant and machinery, that is to say that that land and building which were constructed for sale, number one, and number two, that it had no connection with the business of the SSE and did not contribute to the function of the business. So this is an argument which one will have to cull out or bring out from the judgment.
Thank you, sir. So the next question is, hypothetically assuming that grade is allowed, as consider that it's a mall and the grade is allowed per section 17(5). Now, if tomorrow I sell the units as a completed building, as a immovable property, so in that case, do I need to reverse the ITC?
Yes, I would suppose so.
The question is that because it's a future becoming exempt, that's why grade good. So that's going to the next question.
Arugda, I have a question.
Yes. Ankit, I think you can ask, then I think I'll go to the question in chat box. Yeah.
Sir, one small question, sir. Suppose like factory shed and everything now coming into this definition, if it satisfies plant. So there in factories, we see there are administrative buildings wherein the accounts team and all those persons are sitting and doing the administrative work. So to what extent the construction of the word plant, basis the jurisprudence under the income tax law, one can go forward, sir? Can an administrative building be qualified as a plant for the purpose of availment of input tax credit to that extent? If you can throw some light.
Yes, it's a very, very good question. And I think, in my view, if I were to put it in very plain words, the answer would be no. Administrative buildings would not be able to justify their connection, direct proximate connection with the business that is being conducted. There would be general administrative purposes. So you will have your accounts team, your managerial team, and the legal services. Everybody would be housed in that administrative building.
Yes.
It's not a building from where the operations are conducted. So let me give you another example. Let's take the ATC, the air traffic control. Now that's a civil structure. It's a tower. There are people sitting in it. There are computers installed in it. There are telephones, radar systems all installed in it. Even though that is a civil structure, it would qualify for being eligible under for ITC purposes. But a plain vanilla function of administrative staff, which is sitting over there, HR staff or any other, would probably not qualify.
Thank you. Thank you very much. Thank you. Arugda, you are not audible. Arugda.
Sorry. Sorry, I'm not able to hear you.
Am I audible now, sir? Yeah.
Yes, you are.
Yeah. So the question is that whether the functionality test that has been discussed in the particular judgment, whether it was discussed in any of the earlier judgments.
So they have not been discussed in the context of 17(5) C&D. They probably were discussed in different context, like for example, Income Tax Act, whether investment allowance or depreciation, or even in deciding whether so we know that Sirpur paper is a leading case on what constitutes the mobile property, and similarly that X-ray case of the Supreme Court, where the Supreme Court said that if attached to the floor only for convenience, so that it doesn't shift or move, then it's not an immovable property. But if it is attached in a manner that because of to avoid vibrations, so that the functionality of the machine or the plant does not get affected, then that it constitutes immovable property. So the functionality test has been used by the Supreme Court in the past, but in very different context.
Thank you, sir. The another apprehension is that now with this recent judgment coming in, if the word is amended in section 17(5)(d) to plant and machinery, what could be the impact of it?
Again, it will mean that the explanation then would apply, and the danger in the explanation is that it excludes land, building, and civil structure. That is the biggest bone of contention. So on one hand, plant and machinery has been held eligible and civil structure has been excluded. So conceive of an idea that you have, as I mentioned, a textile mill. The argument of the revenue is going to be that while your plant and machinery, I will give you the credit. The foundation also, I will give you the credit because the machine is installed on a civil foundation. But I will not give you for the building or the superstructure because superstructure is excluded. And your argument is going to be, yes, superstructure would have otherwise been excluded, but for the fact that now the Supreme Court in para 52 and 53 have said, introduce the functionality test. So if I can demonstrate that the building has been designed in a manner that ventilation, the air conditioning was such to maintain a particular temperature for the production of my products, then in that situation, it's not just a civil structure. And it comes into existence from the very basis at the time of building plans and design and construction to be catering to my manufacturing process. So this is where the arguments will lie.
Thank you. So, and the next two questions are on similar lines. Like, if you am giving a property on lease, any commercial property on lease. So in this case, whether that property will be treated as that building will be treated as a plant.
So again, it's the same thing. Whether mall leasing of so you have service apartments which are akin to a hotel, but you have service apartment or you have a leasing model. Then, as the Supreme Court says that that is why they send it back and remanded it to the High Court to examine whether in that case it was designed for carrying on the business of leasing. So you'll have to show that I am into the business of leasing, and as a result of that, I need to construct.
Right. So that become very important. That the fact that I'm into the business of leasing, that needs to be demonstrated by me. So, and one of the last questions after that will. So the last question is, I think, that is already discussed. Whether ITC on works contract used in warehouse is eligible. So I think that is already been discussed by you. Or you want to add something onto that?
No, nothing further to add.
Yeah. So finally, we have a young member from Kolkata, Shubham ji. Can you unmute yourself and ask the question?
Yeah. Hello, sir.
Yeah.
Hello. Thank you so much for the wonderful discussion, sir. I have a question with regard to 17.5C now. Now, 17.5C still uses the term plant and machinery. So, works contract services for plant, construction of immovable property, ITC is still blocked. So, I'm trying to understand the difference between 17.5C and D, because while C talks about input works contract services and I am a person constructing on own account, in that case, would I fall in 17.5C or D? Because I would still be constructing a building and under 17.5C, I would still be blocked.
I think you need to get the facts a little more clear, because in the works contract, you have given the contract to someone, so there is no question of you constructing it on your own account. So the question is, who is the developer? Who's the man who's actually using the brick and mortar and steel to construct? So when you say on your own account, that is a phrase used only under 17.5D, 5C. So in 17.5C, by very necessary implication, there is another party to whom you have given the works contract. As I gave the example of L&T, you want to construct a building or a airport, you give the contract to L&T. So the works contract comes in. You may say, no, I will construct the airport myself, the building myself. I will buy steel, I will buy cement, I will buy services of an architect, a structural engineer, and then I construct on my own account. And you are in 17.5D. So you should get your facts absolutely right. And you will not have a hybrid situation of a works contract on its own account.
So my case is when I'm giving it to someone for construction. So in such cases, I would still not be able to probably then take the benefit of this particular judgment. In such cases, probably even renting would not save me. And even if it is for a particular purpose and the specially designed machine building or all other functional test requirements, I'm satisfying.
Which is what we have been discussing. That is over the last 1 hour, as I mentioned, that is going to be one of the most debatable questions. That if you are covered by 17.5C, the moment you say 17.5C, you get hit by the definition of plant and machinery when it excludes as land, building, and civil structure. So the moment you fall under 17.5C, you get hit by the exclusion in the definition. And will the revenue therefore say that I am not really concerned with the functionality test? I'm not going to give you the benefit of paragraph 52 and 53 of Safari Retreat's judgment. I am going to say the moment you have a civil structure, for whatever purpose it is used, I am not going to give you the credit. Whereas you are going to say, no, now you have to read the test laid down in paragraph 52 and 53 into the definition. So if the land and the building, land, of course, we are not discussing, land will be a rarest of rare cases where it is used for a particular purpose. As I mentioned, it could be a port or an airport. But land by itself, leave aside the land, that's a very complex example to be discussed in this meeting. But let's take building. So building, if you are able to demonstrate that it is used for a particular purpose, is designed for its very purpose from the very birth or inception, then you could probably say that even though I have given a works contract, but the building is so directly connected to my business, therefore I must, though building is excluded from the definition of plant and machinery. It's a very nuanced argument, but it's an argument which is open, and that is one reason why some of the SSEs believe that there is something to cheer about in the judgment.
Got it, sir. Thank you so much.
Thank you very much, sir. So I am indeed, we are really privileged and we are really grateful to you for the wonderful discussion that we had. And just to hear it from you, I think it's a kind of a blessing for all of us on this auspicious Tritiya of the Navratri day. And Durga Puja is a very wonderful celebration in Kolkata. So we are based on the city of joy. So thank you once again, sir, at giving your kind consent at such a short notice. We are indeed, every participant I think has a lot of value addition from this, and we'll be taking forward. So we'd request our President, Madam, to kindly share a few words.
Yeah, thank you. Before she says that, in fact,
Yes,
I was
sir.
surprised that during Puja holidays, you have asked me to join this seminar. I said, I don't know how many will be interested in a subject like this in the midst of your holidays. Anyway, enjoy the rest of the festival, and
Thank you, sir.
my best wishes to all.
So just because of your presence, just to share with you, sir, we had around 120 plus unique participants. So I think people were looking forward to this judgment. So thank you, sir. And President, Madam, a few words from you.
Thank you. Thank you so much, sir, for sparing your valuable time and giving the deep insight on the Safari Retreat judgment, sir. Actually, people were waiting to hear you, to listen you, and to get clarity. And it was a wonderful deliberation. And as Arubda said, we had 120 plus participants. So people have gained and have come to know a lot about this judgment, sir, from you, sir. So thank you so much, sir, for spending your valuable time on this auspicious day, sir.
Yeah. And our executive committee member, Ankit ji, your final words before we just conclude the session.
So it's fine, sir. Thank you again from all of us for sparing this time and hearing from the horse's mouth, as we say, because you argued this matter before the court and then reading 90 odd pages and getting a summary in 45 minutes from the person who himself has argued. That's something for all of us to cheer about, sir. And at least we have got much clarity as to the functionality test, how it will be applied. And as you have rightly told, that High Court may also remand it further. So we are back to square one with the proper officer disallowing everything. And of course, but the future is bright, sir. Again, we are square one, we will come down, but future, we see the future to be bright on this subject. Thank you very much for sparing your time, sir. It was a pleasure.
Thank you very much, sir. And thanks to all the participants. And sir, also one more thing we want to share. We have participants from across the length and breadth of India. So from Delhi to Rajasthan to Gujarat to Maharashtra to Kerala to Andhra Pradesh, Karnataka, from across India we have participants. So thanks to all the participants for joining from across India and reposing your faith in GTPA Kolkata. Thanks to everyone. Thanks to President Madam for giving us the wonderful platform to do this.
Thanks to you, sir, for organizing such a wonderful webinar.
Thank you.
Thank
Thank
you.
you very much,
Thank
sir.
you.
Thank you, everyone.
Thank you.
And have a
Thank you.
wonderful
Thank you.